today on Fired Up.
We're going to talk about the state of New Jersey predominantly because we have two gigantic cases in the state of New Jersey that will seriously affect the rights of firearm owners, and concealed weapon holders are people that would like to carry concealed tremendously.
Unfortunately, and we see this in a lot of laws all over the country, when this particular statute was written, it probably only applied to those people the political in-crowd wanted it to apply to.
When I went through the case, the state constitution in New Jersey has no gun rights in it.
Please, I don't believe you just said that.
And then, Mike Rogers brings you the moron of the week and the less than lethal segment. And Tony D will have some historical firearm demonstrations for you. That's here on Fired Up today.
We are here today again on Fired Up. I'm your host, Bob Irwin, from the gun store here in Las Vegas. This show is all about guns, politics, and self-defense issues that come to affect everybody every day. My guest panel today includes Tony D, our gunsmith and a firearms trainer here at the gun store, Attorney Michael Giles with Creed & Giles here in Las Vegas, our marketing and wedding manager, Emily Miller, here from the gun store, and Randy Sutton, who is a retired police officer here in Las Vegas, written several books, and you can find his books if you'd like at thelegacychallenge.com. Okay, in this segment on Fired Up, we're going to talk about the state of New Jersey predominantly because we have two gigantic cases in the state of New Jersey that will seriously affect the rights of firearm owners, and concealed weapon holders are people that would like to carry concealed tremendously. We have one that's a state case where we have four gentlemen trying to change the state law, and we have another that's a federal case that's been in the hopper since 2010 that is about to go from the appellate court to the U.S. Supreme Court. And Michael, if I can ask you to at least start in on the state case. This is pretty complicated stuff, but it is so important to what you're going to find in your future if you're a gun owner.
The important thing to remember about New Jersey is, as one of the older states in the Union, their gun laws have been around for a very long time. The law that's under challenge in the state case goes back to 1924. Their original gun laws were in 1905, and they were mirrored by the New York laws. In 1924, the law was changed in New Jersey to say that the only people who needed to carry firearms were those with a justifiable need.
I'm sorry, what's that?
Well,
what does that mean?
The law has been construed for the last 50 years to mean justifiable need means an imminent threat of danger. And they would tell you that just walking down the street where you might get mugged is not imminent enough. Basically, when the New Jersey courts have ever looked at this particular issue, what they've said is, were you recently mugged? Is there a credible and verifiable threat to your life? This is so off the charts. In 1968, the law was challenged because a couple of private investigators who did some, pretty cop-like things were denied the right to carry firearms because every day they weren't in danger necessarily.
Oh, you have to be a victim in order to protect
Basically,
yourself.
In fact,
exactly.
The law itself is very strict. Randy, I know that you're from New Jersey, you've worked in New Jersey. It's so strict that even when police officers retire, they may or may not be able to carry a firearm, depending on whether they can carry under the police officer's rights. But if they try to get a permit, they're told, well, the threat to you is now stopped. What's happened here is these four individuals have filed a lawsuit in state court. Now, recently, the United States Supreme Court codified that the Second Amendment applies to the states through the 14th Amendment through the cases of Heller and then later on McDonald. And that's going to be very important because until the McDonald decision said states have to play on an even field with the federal government, they could refuse to act on Second Amendment claims because it wasn't part of their body of law. Now that it is, they have to address it, and the state Supreme Court has agreed in New Jersey to hear this appeal. Now, what they'll do with it is anybody's guess.
I have a guess.
But in the last 45 years, they've basically shuffled this off, just like the United States Supreme Court did all those years from the beginning, back in the earliest Supreme Court case in the 20s and 30s, all the way up to 2008, when the Heller decision actually was being kind of warped around.
Didn't this come from like the gangster laws, the old gangster laws, basically, with the
That's the argument.
justifiable need? Yeah.
The argument was that New Jersey was a civilized place except for certain people.
Right.
Unfortunately, and we see this in a lot of laws all over the country, that when this particular statute was written, it probably only applied to those people the political in-crowd wanted it to apply to. If you were a business owner in 1924, 1928, 1935, I'm sure you could go to the mayor and get a carry permit. It only became later in the 60s and 70s when it became a big bludgeon that was used against anybody that wanted to defend themselves outside of the house.
So it was a good old boy system back then, and it's evolved into a more stringent good old boy system now.
It really has. And I know we recently talked about a case where somebody passing through New Jersey got into trouble with some guns in the car, and unfortunately, their law is now, since Chicago and has gotten on the bandwagon, and they've got a fairly decent carry permit system mapped out. We don't know how that's going to shake out. Now, the three most stringent are New York City, the state of New Jersey, and the District of Columbia. And this is going to be the next big battleground. This state case is likely to change the format of what we see back there.
What I'm seeing here, Michael, is when I went through the case, the state constitution in New Jersey has no gun rights in it. It has nothing even mentioning it. There's no equivalent of the Second Amendment, or stricter or not, there is no constitutional right to have a gun in New Jersey.
Right, and remember, when all of the states formed their own constitutions, under the 10th Amendment, the federal government was hands-off. The states had a right to form whatever laws they wanted, and New Jersey was one of those states that was on the outs in the whole Second Amendment argument. In fact, the Second Amendment as we know it wasn't a unanimous decision by the founding colonies and put into law. And New Jersey was one of the ones that kind of fought against that, and when they formed their own constitution, they put no gun rights into their constitution. They also have no right, as I understand it, they don't have any version of a stand your ground type law. They have a requirement that you make reasonable efforts to avoid the conflict.
And here's how that practically affects people. Having been a law enforcement officer in New Jersey for 10 years, I saw some very archaic things take place because of these gun laws, including I was actually forced to arrest a man who was passing through the state of New Jersey. His car broke down, and an auto mechanic saw a gun in the trunk of his car when he went into the man's trunk. It was a weapon that had been given to him by the President of the United States in service, in gratitude for service to his country. We were forced to arrest him for carrying a concealed weapon in the trunk of his car because of these laws. And talk about trying to, I was unfortunately the officer who was ordered to arrest him. And quite honestly, watching what I consider to be an innocent man be led away in handcuffs after all that he did for his country was, to me, an insult. And it was, but that's the practical effect of these laws.
And the laws aren't much better. In 1971, Justice Nathan Jacobs, in a ruling that dealt with this very specific issue, and I'm paraphrasing here, but basically what he said was, we don't want laxer gun laws because we don't want a Wild West mentality. Now that's been the hue and cry of people who don't want firearms and personal protection all over the country. We have not seen that happen. But we're still talking about a state where possession of hollow point ammunition outside of a few specific caveats is a felony. So the ammunition that is standard for police officers and civilians alike across the country can get you thrown in prison in New Jersey, even if you're a police officer from another jurisdiction who comes in New York, right?
I know of a case where a New York police officer crossed into New Jersey, got stopped for traffic and whatever, but they discovered his duty gun with hollow point, or off-duty gun with hollow point ammunition, and they arrested him.
The long and the short is no one expects the Supreme Court of New Jersey to actually overturn this law or even loosen it up. This is one of those fights that's being had because then they can move on to the next level if they don't get what they want.
Yeah, they need to be turned down by the New Jersey state in order to appeal it into the federal system.
Correct.
Like the second case that's coming up now is already like a step ahead of that. But it's a slightly different case.
Just a little.
We're going to have to break for just a minute for some commercials. We'll be back right after this.
Our panel will discuss.
This is a very, very scary case.
Those are the permits that newspaper was publishing, the location of all of those. They were premises permits. These people in the county have the right to have a firearm. They also published the list of people who could carry a gun out in public.
Please, I don't believe you just said that.
That's here on Fired Up. Stay with us.
We are back here on Fired Up, picking up this case with basically the gun owners of New Jersey trying to go after the federal government to see there will be a case that hits the Supreme Court from this, I'm sure.
I would expect so.
The question of where it's going to fall is the very scary thing here.
Yeah, the problem with this particular case is now we have what's called a circuit split. Whenever there's a unresolved question of law, and unfortunately the Supreme Court left open a lot of territory in the Heller decision and the McDonald decision, and that's kind of their modus operandi. They never want to reach issues that weren't part of the core case. And so whether or not we have a right to self-defense outside of the house is the open question. Right. The Seventh Circuit Court of Appeals, this is the famous Moore v. Madigan case out of Chicago, said, well, there's no point in having a self-defense right if you can't defend yourself where you spend the majority of your time. Therefore, not having a manner to allow carry of firearms is a violation of the Second Amendment. The Third Circuit Court of Appeals on the 31st, this is a brand new decision, right, ruled virtually the opposite. Now the difference between the two is that New Jersey does have a system to get a CCW. It's just that regular humans don't qualify. And that's kind of common in a lot of places. You know, California has a system to get carry permits, but if you look at the state of California, it's hit and miss whether or not the county you're in actually has any. New Jersey has the standard we talked about, which is justifiable need. And in the federal case, the three-judge panel, the two judges who were the prevailing opinion, which is no, you don't have an absolute right to self-defense, went into a lot of discussion about what is justifiable need. They talked about imminent danger to you, verifiable. They talked about the history of New Jersey, the concern that life would be bad if everybody walked around with a gun. We'd be the Wild West again. But they said a couple of things that I think is where the Supreme Court's going to step into this. When federal appeals courts, whenever there's a governmental interest that's taken to the courts, the court has to ask itself first what level of scrutiny applies. There's rational basis scrutiny, which is there a good reason for the law? And if there is, then it's legal. There's intermediate scrutiny, which is basically, is there a good reason for the government to have this law that doesn't really infringe on everybody's right? Core constitutional privileges have almost always been strict scrutiny. To pass a strict scrutiny, They must show that it is the least restrictive means possible to protect a compelling governmental interest. So we just want to keep the crime rate down would be intermediate scrutiny. Strict scrutiny would be if we don't prohibit this from happening, anarchy will reign, and they can't get there. So the court used intermediate scrutiny. They also said something that every first-year attorney hears at some point. There's a concept called stare decisis. Courts don't want to disturb previous opinions. And so they'll say, well, we're standing on the history. It's a long-standing right, and therefore it is presumptively lawful. The problem with that is when you look at something that deals with constitutional rights, and you say, well, we've been violating it for 80 years, therefore it's lawful, okay. It's okay.
Sure.
The classic example of that is Korematsu v. U.S. This is the case that came out of the internment during World War II. Now, it's still good law. The court did not say that that was unconstitutional. It said we shouldn't have done that, but it didn't say it was unconstitutional. So based upon the theory of the Third Circuit Court of Appeals, the government could round up any group of people that they want to and inter them in prison camps indefinitely and then say, well, it's presumptively constitutional and legal because Korematsu is still the law of the land.
Did this group have to bomb Pearl Harbor first, or
you know what?
Just anybody?
That's
we don't know.
the problem. We don't know.
Please. I don't believe you just said that.
The simple answer is, contrary to Randy's disbelief there, it's not a question of what they have to do. It's a question of, is the law so important that we'll allow this broad discretion?
Right.
And following Moore v. Madigan, the Seventh Circuit has clearly said, no, you have a right to carry outside your home. The state must come up with a scheme to issue these permits. It's in direct contravention. Although here's the real question. The Seventh Circuit basically said you can't have no permits. That was Illinois, the last state in the union to actually have a permit scheme. They said, Illinois, by this date, come up with a system where we're going to do it for you. So Illinois went out and came up with a system. What nobody knows is, could Illinois have come up with a New Jersey system? And the courts would have said, well, now you got a way. That's
Right.
good enough. Because that's basically what's going on in D.C. and basically what goes on in New York City. And those jurisdictions haven't been struck down yet or even been taken to the courts over this issue. So this is going to be a really interesting argument. The dissent in this particular case, by the way, and the dissenting judge was a visiting judge. They had him sit on the panel because they couldn't put the standard 3-judge panel together. He said, those guys got it wrong. They got it absolutely wrong. They keep referring to these laws from 1924 and 1971 and 1966, and they have no bearing.
Fight him back.
Yeah, no, he probably won't sit with them again. So this is a 2-1 split. It wasn't unanimous. The appellants have a couple of options here. Now they can just go and try to get cert to the Supreme Court right away, or more likely the first step is they will ask for an en banc hearing. I don't have any real hope because this appellate court has been the strictest, most anti-gun appellate court out there.
Of course.
For its entire existence. So it makes the Ninth Circuit Court of Appeals sometimes look rational on guns. And so this is going to be a long, drawn-out process. If it is picked up by the Supreme Court, it's not going to happen within 2 years probably. It'll have to be writted, and then if they take it next term, they'll hear the arguments after October when they go back into session, and the decision won't happen until sometime late next year.
Not good. This is a very, very scary case. I can see that if New Jersey is able to maintain their position on their laws, we have New York that'll do the same thing, and probably Colorado if it doesn't split into 2 states between now and then. There's
In New York, it's, I mean, I still have my New York permit. a pistol permit, and you have to have a concealed weapon permit in order to even buy a handgun. You have to have the permit before you buy the gun, actually. And my permit it's good for life. My father-in-law brought a gun back from Belgium, World War II, and the picture on his permit is in his World War II uniform. And but it says right on the permit, not valid in New York City. So New York City is the cutoff line. Everything above New York is okay. Below.
And I've always wondered if they prevail in New Jersey, I would not be surprised if we don't have some kind of an action under an equal protection claim. You know, everybody else in New York State can get a permit fairly easily by going to their local chief of police and saying, I have a need. But in the city, it's really still a power issue. You have to be a somebody or have connections to get it.
There's two types. There's a premise permit and a carry permit. So you even have to have one to get one in your premises, a permit.
Yeah.
It's really,
a permit to possess a pistol.
And those are the permits that newspaper was publishing the location of all of those. They were premises permits. These people in the county have the right to have a firearm. They also published the list of people who could carry a gun out in public.
My list, my permit, I looked it up. Because there was no activity since 2010 on my permit. All it has is my name and everything. But everybody in New York, I can go right on the computer right now and find out who has a concealed weapon permit in the state. If you've had any activity on your permit, if you bought or sold a gun since 2010, then your name, your address, all your information is right there available to anybody. Right on, it's amazing.
A different issue, but this gets just more and more complicated. As everybody out there knows, that Illinois is forced now to issue concealed carry permits, and their system there is there's a board of police chiefs, sort of like in Nevada, that sets what those laws are in general. And the issue came up to them a week and a half ago that, well, what do we do now that we theoretically have permits? They don't have any actual yet, but what do we do with people coming through from other states? And part of the federal decree was that they would honor other states' permits. So what that law enforcement group decided was that people coming through Illinois from out of state could carry their loaded pistols in their car. But if they step out of the car, the gun has to stay in the car in a locked container that meets their state standard for a locked container in a car. So they can only have their pistol while they're in the car, and if they step out anywhere in the state of Illinois, they can't. That was the ruling for 48 hours. I almost gave it to you on a class note, and the Illinois Attorney General overruled that somehow and said, we're not going to do that. So now they're back to where they were. But for one brief period, you could have driven through Illinois with your gun in your car.
Wow.
I'm sorry you missed it. It would have been great.
Tony would have jumped in his car and headed out just to do it.
Garden spot.
We're going to take a little break here, and we'll be back in just a moment. Don't go away.
Coming up a little later, our panel will discuss.
Well, this would be a classic example of, instead of handling it yourself, call the police and make a noise complaint so that there is some intervention there.
And clearly they're both disturbed in separate ways. I don't have PTSD, and if somebody's blowing an air horn, that would seriously bother me.
Hello, I'm Mike Rogers, Director of Safety and Training for the Gun Store, with our Moron of the Week. He's going to help us illustrate what our customers don't do, and we hope you won't do either. They're going to use this for its training value and enjoy it at the same time. Either this guy's friends set him up for the accident, which is not a good use of a firearm, or he truly does deserve the title of Moron of the Week.
Coming up a little later, Tony D will have some historical firearm demonstrations for you. And our panel will discuss.
Well, this would be a classic example of, instead of handling it yourself, call the police and make a noise complaint so that there some intervention there.
And clearly they're both disturbed in separate ways. I don't have PTSD, and if somebody's blowing an air horn, that would seriously bother me. Don't go anywhere. Thanks for watching Fired Up with Bob. We're going to take some time to answer some viewer questions, so please write us at questions@firedupwithbob.com. If you have anything you want to ask us, we'll go ahead and send some questions to Bob and get your answers for you. A viewer has asked us whether 9mm or 40 cal is better for home defense.
That really depends on how much you shoot. The 9mm, it holds more cartridges in the same size pistol than a 40 does. Usually if a 9mm will hold 15 or 16, the 40 will only hold 12 or so. I personally opt for the more shots at the guy rather than the slightly bigger cartridge. It's really a personal choice, but you want my opinion, you should go with a 9mm.
One viewer has asked us whether pepper spray works on drugged up guys. I think what they mean is when obviously people are hopped up on drugs, sometimes they're immune to...
They're feeling no pain.
Yes.
And the answer is yes and no. Depending on the drug, you may get no reaction at all with pepper spray. Mostly it works, especially in the eyes and in the nose, where you can mess up his breathing. If you're dependent upon pain, sometimes it won't work, but usually getting the respiratory system, it will take him down, pepper spray. It's not my first choice with a drugged up guy with a machete, but it would be way ahead of nothing at all.
Don't bring pepper spray to a machete fight.
Exactly.
Got it. Another customer would like to know if they can buy a gun on the internet from a dealer.
Actually, yes. The gun would have to be shipped to a dealer. If you don't live in the same state where you're buying the gun, the guy would have to ship the gun to a dealer in that state. If you are buying inside the same state, yes, you can if it's a rifle. They have to do some stuff. We can't do that in Nevada, but they do some stuff to verify the 4473 and the Brady and so forth. But it can be done. You'd have to talk to the dealer in your state. If you're going into another state, you need to go through dealers in all cases.
Can I carry my gun in New York State with my Nevada CCW?
Only if you like being arrested. New York doesn't honor anybody's permits for anything, and there have been cases even where officers carrying on their 218 retired officer carry have been hassled but not gotten all the way to jail carrying their guns in New York, particularly New York City. Just don't visit or don't carry your gun.
You always want to be sure to check the state laws and to check if it's reciprocated before
Right,
you
there have
travel with
been
your
numerous cases where people have fallen over that law and ended up in jail. So.
Another viewer has asked us, if I have an old AR-15 in California and never registered it, can I sell it in Nevada?
Wow. Short answer is yes. The long answer is the gun being in California now and not registered with the state authorities makes it contraband, where you could be arrested and go to jail for possessing a gun that is now illegal if it hadn't been registered in their amnesty years ago. So I would suggest you can sell it out of state, but you want to drive very carefully and very slowly and stop at all the stop signs till you get out of the state of California. Then look for somebody who wants to buy your gun.
Another viewer asked us if a .410 shotgun is good for home protection. Bob?
Sure. Mossberg even makes one specifically for that with a little foregrip on it and so forth. Smaller statured people find them very effective. The loads for them are very decent for home defense. They make a lot of noise and they're effective. No problem at all.
Can anyone sue me if I don't use my gun to save them from attack?
Wow. There is no requirement under any of our laws that you intervene in somebody else's problems. There have been cases where you certainly want to intervene. You see a child being doused with gasoline and lit on fire. Do you want to intervene in that? Of course. Where you can see something that you know is wrong. Can they sue you for intervening? Yes, they can. It's kind of the same rule as Good Samaritan laws when you stop at a car wreck and go to help somebody but do something that actually makes it worse because you're going beyond your knowledge. There can be a problem there. That's probably one to bring up on the show, and we've got an attorney here, actually.
Know a couple of those guys. Now, a customer would actually like to know how often they should practice shooting.
Wow.
To stay up with their skills.
Stay up with your skills, I would suggest every 90 days at least. If you're going to become skilled, the motor skills, the muscle memory fades fairly quickly. Going and shooting recreationally would help. If you become a regular shooter, you're going to do it every 30 days anyway, but at least once every 6 months. We have people get concealed weapon permits. They don't have to requalify for 5 years here in Nevada. And if we didn't coach them back through it, they have forgotten how to load their gun, which end of the gun the sights are on. I mean, it's really pathetic in some cases. So you need to practice with your gun. If you need it, it's going to be because your life depends on it. So practice.
The next question asks if homeowners insurance will cover the person if they shoot a trespasser. Bob.
Generally not. If you shoot a burglar, a criminal coming in your house, the insurance in general covers you for accidents, not for on-purpose things. So if you do an intentional act, most insurance does not cover that. They would cover you if you accidentally shot the burglar, but they wouldn't cover if you shoot him on purpose. You can get riders, and some companies do. You need to call your insurance agent, and if you keep guns in the house and you want to use them to defend yourself, make sure you get a rider on your policy that says you're covered.
Now, another person wants to know if dogs are any deterrent for burglars.
Well, they are. They make noise. Actually, the little bitty yappy dogs are better because they wake you up. The bigger dogs tend to not be as yappy, and the problem with dogs is most of them can be bribed. I know you don't think your dog would take a bribe, but a juicy steak that just came off the barbecue grill will probably keep him from letting you know that somebody's breaking in. So I would suggest the little yappy dogs rather than the big ones. But it's up to you. You need to train your dog not to take food from anybody else to make a dog really worthwhile.
So people need a toy poodle and a shotgun at home, correct? To be safe.
Sure.
Our next question asks if they should practice loading their gun in the dark. Now, what are the benefits of loading your gun in the dark?
There are huge benefits, knowing how to work it when you can't see. Most crimes take place at night. Obviously, home burglaries usually are at night and it's dead dark. If your gun malfunctions or you didn't put the bullets in it because you've got a child at home or so forth, you're going to be incredibly nervous. Your fingers aren't going to work very well. You need to practice that skill. Most places you can buy dummy cartridges so you don't accidentally shoot yourself, and practice loading and unloading your gun in a dark room or without looking at it so you can do it just by the touch, because you're going to be in the dark when it happens.
Thanks for watching Fired Up. This has concluded our question portion. Please feel free to write us at questions@firedupwithbob.com if you have questions for Bob or any of our other panelists. We'll be right back.
Hi, I'm Mike Rogers from the Gun Store. We're going to talk about protecting your family when the light conditions aren't perfect. We know that we don't get to pick the time and the choice when the bad guys are going to come and try to hurt our family. We also know that we can't shoot somebody until we've made positive identification. Modern science has made this a lot easier. I've got in my hand a 250 lumen flashlight. Just shining that in somebody's face may hurt them, but I can definitely identify them before I use my firearm. Absolutely essential that I know I'm not shooting my kids, and I know that the background is clear. I can achieve the same thing with one of these. This is a Surefire X400. This is the same company that makes this. This is a light laser combination. 230 lumens of illumination and a laser aiming device built into the gun. I can turn it on permanent use. I can have it pulsed for intermittent use, which is the ideal way, and I can also use it left or right-handed or using both hands in conjunction. The only downside of this, to illuminate my target, make sure that it's a threat, I have to have the gun pointed at it. You should have both if you're going to carry one or the other. You can get the light independent of the laser if you live in a state that doesn't allow laser aiming devices, such as California, and you can get lasers that are independent of the light. You have lots of choices these days, but what you don't have any choice of is the fact that you have to positively identify the threat before you can shoot it. This is extremely important. A lot of crime happens at night. We don't have control of that. We do have control of the fact that we're going to shoot the right person. We've positively identified the threat.
You know, once in a while here at the gun store, we get something in that I can just foresee is so dangerous that we don't want to sell it. And that may give you the wrong impression. This is a .380 automatic that just came in with a shipment of guns. And this little gem is a real gun. And I cannot imagine anybody foolish enough to have this thing in their home. It looks more like a toy gun than most toy guns I've ever seen. And it is a real operatable .380 automatic, holds 9 shots and actually works. If you've got anything like this in your house, we're not going to sell this gun obviously, but if you have anything that looks like this in your house that's a live gun, you need to get rid of that, because this is walking danger right here with children.
Hi, this is Tony D from the gun store in Las Vegas. Thanks for watching Fired Up with Bob. Today we're going to be talking about another historically significant firearm. This is the Beretta Model M9. This is the gun that replaced the Colt 1911. And there was a lot of controversy about that. A lot of the military guys did not want to give up the .45 caliber round to the 9mm round. And they felt it was a step backwards. All of NATO used the 9mm round, and we were kind of, not forced into it, but we did adopt the 9mm cartridge. Beretta went through extensive testing with the M9, and several other manufacturers of pistols were also involved in it. They had guns in the test. Ultimately, the M9 was the one that was chosen. This one here is kind of a different one. It is fitted with a threaded barrel for a suppressor, and it does have the military markings on it. It's a very, very nice gun. It's a pleasant gun to shoot. When I was a police officer in Rochester, this is the gun. This was my carry gun. So I'm very familiar with it, and in my opinion, it's a nice gun. As far as a .45, I like the .45 also, but it's a hard choice. This one holds 15 rounds, where the .45 only holds 7 in the magazine. This holds 15. It was a double action pistol. In other words, when you pull the trigger, the gun would fire in a double action mode, then it would cycle, and then fire in a single action mode, where the 1911 was strictly a single action gun. They felt that this one was safer. You can carry it with the safety on and the hammer down. You can carry it with the safety off and the hammer down, and it depends on what you're comfortable with. It's a very, very pleasant gun to shoot, and it's very, very accurate. I'm going to put it on decock, so we're going to start off. The first shot's going to be double action, and then the subsequent shots are going to be fired single action.
We are back here on Fired Up. I was going to mention, as that segment ended, we were talking about all these potential problems in New Jersey. We're continually hearing in politics that 80% of the people in the United States want to do that, and 20% disapprove of this guy, and 10% like that guy. And they like to work their political views off of polling. NewJersey.com, which is a website that is a compilation of several New Jersey city newspapers and county newspapers ran that poll in the last couple of days. And they questioned in the poll, would New Jersey be safer if more people carried concealed guns? And the answer was yes, 82% of the time. The question was, would you vote yes because criminals wouldn't know who was packing, so they'd be less likely to strike? And 82% of the people in New Jersey said yes. The numbers that said no, guns will spur more violence, not less, was 16.7%. And the not sure, I don't know where I stand on this, I don't care about guns, whatever, was 1%. That was 15 votes out of their 1,489 so far. The poll is still running in the Jersey papers because of this case we're talking about, to see what the public really thinks. And the public really thinks 82% they'd like to carry a gun. That would seem to be a realistic way to go. The right to defend yourself has to be at the top of the list.
But apparently it doesn't matter that the people have spoken. I wonder if there's a way they could put this on a referendum and vote on it.
I'm not even sure if New Jersey has a referendum system. That would be an interesting thing to look at.
Only if you have a compelling need to have a referendum
Right.
in New Jersey. This second case we're going to talk about is a more straightforward shooting case that we normally use to talk about gun issues and things. This is a fella in Georgia who, a single guy, he's 66, he lives by himself in a house, in a neighborhood, a little separated from the houses, kind of rural. He is a little goofy, so he likes to make noise. He plays his music really loud. He sits on his front porch blowing horns because he likes to hear them. There have been some complaints from some of the neighbors. This fella, the older guy, his name is David Harrelson. He has a stepson that comes by to help him named Jacob Dunbar, and he's living there just doing his own thing and retired and making noise on his porch. One afternoon, he was sitting on his porch blowing an air horn.
How pleasant.
And as usual, all of the neighbors band together. They wanted him to stop making the noise. One of the neighbors came over. He's a Iraq veteran, did a couple of tours, known to have PTSD problems. Apparently the fellow and his wife came over to ask this guy to stop. The 66-year-old man apparently waved the gun toward the woman, causing the veteran to step in front of her, and the guy shot and killed the veteran neighbor. Wow. We can see a lot of ways out of this, obviously. When we have this given, this gets complicated, and it's an interesting case. I'll go to you, Randy, first. That's basically all that happened. This guy's been making noise a lot. They've called the police several times. They've counseled him, so forth. Keeps doing it. He, as I said, he's a little goofy. Preventative measures, the police, I don't know.
Well, this would be a classic example of, instead of handling it yourself, call the police and make a noise complaint so that there is some intervention there. You know, rarely does when one citizen confronts another, rarely is there a happy ending. Yeah. You know, there's always an issue there, and that's, quite honestly, that's what law enforcement gets paid to do. To be the intervening party, and to, if there's an ordinance, you know, to cite or arrest or whatever is necessary, and to confront. You know, we see where this went, and this is very often it starts out as something very, very minor.
I just wonder, if the guy had the gun in his hand, why would the other guy and his wife even approach him? I mean, There's no clarification
You
on
can
that at
see
all.
that on
right?
both sides. You
Yeah.
know.
And clearly they're both disturbed in separate ways. I mean, obviously having PTSD is a very real thing for veterans, and there's a lot of recurring things that happen after war, and I understand that they can be more sensitive. And clearly this guy, I mean, blowing air horns, I mean, that's crazy.
I mean, if the guy had a gun, hidden or whatever, but to go up to somebody in that particular state and he had a gun in his hand, I don't think so.
Yeah, you can wonder why he approached. Well, he's a war veteran. Part of the story said, you know, that he's a serious PTSD person. He's got a short fuse. The noise really bothers him. The noise of birds playing, you know, singing outside his house bothers him.
I don't have PTSD, and if somebody's blowing an air horn, that would seriously bother me.
Well, don't go over to his house.
Clearly, but still, I mean, you know, I think you have to have PTSD to be that annoyed by
Or
somebody.
if you do, have Ryan jump in front
Got
of you.
it. All right.
because,
Yeah.
this is,
Have my boyfriend go fight that battle. No thanks.
Anyway, this was obviously there's preventative here that could have been done. If you're the next door neighbor in this case, you want to call the police and not get involved, no matter how many times the guy's done it. Obviously, he's goofy just looking at him with what he's doing. He's got bear horns and bells, and he likes noise. Living next to a guy who hates noise, so bound to clash. The gentleman is arrested for first-degree murder, as you can imagine, or open murder, I guess, in our parlance, and he's got some mental issues. He gets an attorney. This gentleman is in jail for just at 7 months, almost to the day, and the grand jury refused to turn in an indictment.
Yeah, they came back no true bill.
They came out no charge because they said in Georgia, you're not required to retreat when somebody comes into your house. It's a stand your ground issue. So,
Well, this happened outside the home, correct?
yeah, well, he's on
On
his
his
front
porch?
porch and the guy's in his front yard. But it isn't castle doctrine in your house. This is stand your ground if you have a legal right to be where you're standing. And I'm sure the grand jury didn't like that decision, you know, but now he's got an attorney saying, you know, the guy's a nice old guy. He didn't really want to hurt anybody, and, you know, he's kind of goofy, and we're sorry that this happened, and he's really sorry that he shot anybody.
I can't help but think that there might be more to this than what's on these
Yeah.
than what's on these pages. Because if I believe I read something that there were some injuries involved here.
Yeah, and I left that out. They said that the guy with the noisemakers had some injuries to his face that he claimed were caused by the veteran who came over. Yeah. They were minor injuries, but there were some injuries there.
Fist in
I'm-
the face or
I'm
something
willing
like
to-
that, maybe. Yeah.
Willing to go out on a limb here and tell you that the way a grand jury works, the information that was presented to them almost certainly gave a story of a individual going to another person's house as the aggressor, going onto their property as the aggressor, and probably
Causing physical injury
causing
to
physical
the guy.
injury to the guy. And so this isn't just he said the injury came from this person. They're going to have heard from all the eyewitnesses. The wife's going to have testified, and
And
in
we all
the
know
end-
the old story about DAs and grand juries, right?
a good prosecutor can indict a ham sandwich.
There you go.
So
And that should be clear to everybody listening to the show, that when we present cases like this and we have a 10-minute segment to talk about this is what happened, we're giving you the very, very top edge of the high points and not all the subtleties that often make these cases change immediately.
yeah,
You know, we've got to the point where he walked over there and the guy shot him. That was wrong. But wait, he apparently did contact the guy with the gun and hit him or scratched his face or something. Wasn't serious. Nobody took him to the hospital, but there was contact. You know,
That's a huge difference.
how much contact? How close was he? Did he try to swing something at him? You know, did he try and throw his wife in front of the guy before the guy fired? You know, we don't know. But they go this way, and the point here is we got one guy dead and one guy that spent 7 months in jail, and it would be a whole lot better to let the police handle it. This is not something that either party had to go, I got to use my gun right now because my life's in danger. That's what the gun's for, and if you need to use it, use it. If you can call the police, let them do it. They got free lawyers. Thanks for listening and tuning in to us one more time. We'll be back next week at this same time.